Who hasn't asked one yet? You take control of it.
I'm going to ask a question.
Oh, okay.
You're going to take privilege here.
Exactly.
He's pulling rank.
It's one of the fun things you get to do when you're in charge of a journal. So basically there's two sets of claims that you're talking about here. One is a copyright slander, which shouldn't be confused with a different kind of slander claim against Novell, and you're going to figure out, that case will figure out who owns certain copyrights that you. The rest of the claims that you're talking about here, as I take it, are all revolving around the factual question of, do certain lines of code appear in Linux or not?
Against our property rights from a confidentiality disclosure standpoint.
Okay, so maybe there's two pieces there. One's a contract issue.
Breach of contract.
Because they disclosed and shouldn't have, and the other is over just straight copyright violation or not.
Not from IBM.
But the end users might conceivably violate. Okay.
Exactly.
From other sources.
Right.
So then the question that I have is this. Let's say, and I'm not a copyright lawyer by any means. Let's say it were to be the case that the court said, no, these were sort of developed independently, happens to be the same, but for whatever reason not infringing, and not exactly your code. What happens to all these claims then? Do you have other claims? Do they exist, or is it really just rest on, is it the existence of these particular lines of code in Linux, yes or no? Is that the basis for most of these claims? Does that make sense? It's a slightly convoluted question.
No, it's a good question, and I think the basis for our claims does revolve around the growing up of Linux so rapidly, and how much of that relates to our contract rights or our property rights or not. Okay? Again, when you come back to the point that Linux is a clone of Unix, and we already admit going into the game that a good body of work that's in Linux is okay. By definition, it's okay. By definition, part of it was the BSD stuff. Linus puts up other people's. Okay, fine. X% of that is okay. We argue that X% of it is not okay. That really is the basis of our claims. Red Sox guy.
How would you respond to... It seems to me, I don't have much of a computer background, but from what I've gathered here and trying to put together the notions of copyright in the computer context, it seems to me that you're kind of hiding the ball in the sense that if you put that excerpt from the Constitution back up on the screen, I don't see how you're living up to any part of that notion of copyright as getting the expression out for the public to, ponder and awe at, even if you are awarded your monopoly. You're sort of not even providing the expression for public viewing, and yet you're still acquiring and maintaining all this monopoly power. How do you justify that from a copyright perspective? I'm not trying to argue is there infringement or not, but how do you even sort of, outside of your individual rights and your capitalistic notions, how do you even tie it back to progression of science?
Well, I think we're arguing the other side of it. I think what you're saying is there's an argument that says the progress of science should make all this stuff available for free. We're arguing the flip side of that, which says the best way to progress science is to make this stuff more protectable, that you can profit from it over the years, and that's in fact what the Supreme Court majority decision came down on.
But I just think that when we were talking about interface before, it just sort of seemed to me that this is more of like what you guys are trying to provide here is a functionality, is a certain function, and it seems to me that that is more of like a patent notion, and you should have some disclosure there, and yet here you have this code that you're trying to make, millions of dollars, rightfully so, you've spent them millions of dollars, and yet you're not even providing the expression, which is sort of the basis of copyright.
Let me take a run at this, because we're dealing with, you have a number of different types of intellectual property law. You have patents that you were talking about for a moment, where you publish the invention. You have copyrights for which you may or may not publicly publish the actual expression. I'd say in a lot of ways that Unix is widely published in terms of the binary runtime implementations, the actual program running out there that people are able to see, use, and benefit from. What we're protecting in that case is our copyrighted work, the actual programming code that makes that Unix system, and licensed to many users out there that have developed their own versions of Unix and created derivative works. By contract, they had the right to do so, so long as they kept that derivative work, that product based on Unix System 5, as part of that work that they built, and kept the code confidential and didn't freely give it away. So that's our issue with IBM. They took a body of work, they licensed from us, they built upon it, they created a derivative work called AIX, they took portions of that ultimately and contributed it into Linux. That's one whole body of work for which we have concerns that ultimately can become a copyright issue. All right? We have a whole other body of copyright issues independent of IBM that we also have issue with. So you can't, let's not just muddle it all as, I think a lot of times people confuse intellectual property and think it's only patents. There's many different types of intellectual property. I would even put in contract law as a basis of, in some cases, intellectual property, or defining of intellectual property, deciding what you can do with your derivative works for licensing something or not. So all of those elements have to be combined together to be able to decide, what is allowed, what is licensed out, what is freely available. And in the case of SCO, we have a couple separate issues that are going on here, and it's not, the easiest thing for people to just in 5 minutes looking on one particular website to get the full understanding of the issue at hand. But simply, we are, trying to enforce our rights that we've paid, as you mentioned, a lot of money for, and that's, just part of the process. We're trying to use the legal system to be able to, go through the process and prove that we have ownership of things. But we're not going to publicly expose all of that because a lot of that evidence and so on is confidential information that we have licensed out widely, and if we publicly make it available, it breaks those confidentiality provisions with all those licensees that would be very damaging to our company. So we're trying to give out and expose as much as we can. We're also trying not to just try this whole case out on the internet. We're trying to make sure that the appropriate information is made available to the court system first, such as the evidence we supplied in terms of our case with IBM has been made available to IBM, made available to the court, and if appropriate and the judge so chooses, it may be available more widely or in a public arena. So there's a lot of steps that we have to go through. Our hands are tied on some things in terms of what we can show and what we can't, but we're trying to make as much information available as possible while also respecting the legal system.
Let's take a few more questions, and we'll
Sorry, can I just ask you, there's people watching online and they can't hear unless you...
Well, let me tell them who I am. I'm Kathy Gellis. I'm a law student at BU, and my question had to do with derivative works, that when you put up your slide, you mentioned that there was kernel 2.2, and you described that as the hobbyist. So I'm taking from your inference that you don't have any issue with any of the intellectual property in kernel 2.2. So my question would be, what would happen if all of your allegations are true and you win on all your claims and you have the copyrights acknowledged as being yours, et cetera, et cetera? What happens to all the people upstream who did the Linux up until that point where your intellectual property may have gotten in? If you manage to make it that you end up getting revenue from Linux, what happens to all those prior people, and isn't your work a derivative of theirs where you're benefiting from the work that happened upstream? What happens? How do they get compensated, for instance?
So, very, very interesting question, intriguing question. So we didn't start off with the license. We didn't even roll a licensing program out until somebody came in and said, how can I get access to your IP? So the only thing we said with our licensing program, we've never said, here is a license for Linux. We've never said, this is, if you take this, boy, you've got a license for Linux. All we've said is if anybody wants to use our intellectual property and use it across any operating system, Linux, whatever it may be, here's how you do that. So we're not speaking for Linux as a whole. If we get into a mode where you say, oh, okay, SCO wins all these things, and boy, you got to get your check out and start writing, that's all we're commenting on is the intellectual property rights that we feel are in there as it relates to us.